Ms. Reddy, you may proceed.
Thank you. May it please the court? Counsel? My name is Vidhya Reddy, and I'm here on behalf of defendant appellant Patrick Letscher. In sentencing Mr. Letscher, the district court in this case ordered that his pretrial appearance bond be forfeited and applied to criminal financial obligations in the county. That aspect of his criminal sentence was not authorized by statute and was therefore illegal. The court's authority to apply cash bond to court debt depends on statute authorizing that, and there is no inherent authority for a district court to do so absent such legislative authorization. Application of cash bail to financial obligations used to be authorized under the old bail statutes that applied in Iowa prior to 1978. But with the 1978 code revisions, those provisions were removed and were replaced with what is now Iowa Code Section 811, which no longer authorizes application of cash bond to financial obligations.
What do you think of the amicus argument? The amicus makes an argument that this is really just kind of like an attachment. I mean, I was in private practice, I would do that kind of thing. I knew that somebody was about to give back money that somebody was owed by the recipient of that money to my client, and so you would run into court and just get an attachment. What's your answer to that?
Sure. So the amicus does suggest variously that this is basically either an attachment or an execution, I think is also mentioned in the brief. But it's clear that those chapters require the state to undertake, or the creditor to undertake certain procedures before it can reach whatever property it's trying to attach or execute. And that's not what happened here. It didn't undertake those procedures, and the district court's order does not make reference to an attachment or execution at all, but makes reference to a forfeiture. So really the amicus deals with an issue that's not quite presented in this case. Our position is that the district court's the language in the sentencing order would provide independent authority to reach this cash bond and apply it to these obligations independent of any other tools that might exist out in the world to reach it otherwise when you follow the proper procedure. So in other words, the language in the sentencing order allows the state to circumvent other debt collection procedures that may or may not be available. And like I said, I don't believe the question of whether cash bail could be reached through attachment or execution is presented here, but to the extent the County Attorneys Association suggests that it could, I think that raises real constitutional questions, which again are not raised in this case, are not presented, but given the constitutional dimension of bail, it's not the same as other property.
In order for the attachment, you have to have notice superior. You have to put a bond up before you can attach. And wouldn't the county attorney, if they wanted to use the attachment procedure, basically have to file the attachment action and either, I think you're required a bond in most cases unless the court's going to overturn it.
I believe that's correct,
I
Your
did some
Honor.
of that when people wouldn't pay, but you had to go through a whole process.
Correct. There's a whole process, and ultimately the final execution or attachment is accomplished by the sheriff, not by this association. Seems to say that's what they did, and it wouldn't be. That's not the statutorily authorized procedure for those mechanisms. So the questions here are really whether the sentencing court's application order that the bond be applied to criminal financial obligations is authorized either by statute or whether the defendant's signature on the bond form amounts to voluntary consent and therefore authorizes that under principles of contract law.
You know, I think courts certainly can impose different conditions on release. Could this be considered a reasonable condition of release?
No, Your Honor, it could not. the bond statute governs what additional conditions can be imposed other than the ones that are statutorily enumerated, and this is certainly not statutorily enumerated. So in order to amount to a reasonable bond condition, it has to be directed at the purposes of either securing appearance or ensuring safety of another person or persons, and this provision would not satisfy either of those purposes. In addition, it's clear that it wasn't actually imposed as a condition of release in this case. It's not something that the court was attempting to impose as a condition of release, because the only condition of release set by the court at the initial appearance and then continued subsequently was the $2,000 cash provision. So there was no separate provision entered by the court, and a condition of release would have to be set by the court, not by the jail or by the arresting officer. We also know that this isn't a valid forfeiture under Chapter 811 because bail can only be forfeited if a defendant fails to appear or surrender to custody at the time judgment is entered, and Mr. Letscher did make all necessary appearances and ultimately surrendered. Neither is the defendant's signature on the bond form a voluntary assumption of this forfeiture provision. While it's true that defendants can contract away certain rights, contractual terms will be enforced only if they are consensual and voluntary. And under some of the principles articulated in Balden, that is not satisfied in the present case.
Counsel, if we agree with your first argument that the statute controls and the statute doesn't allow forfeiture here when he does show up, we wouldn't need to reach that Balden argument, would we?
I believe that's correct, Your Honor. And to an extent, that's what the Florida and Pennsylvania cases I cited as additional authorities, that to an extent that's what they say, is that if there's not independent statutory authority signature, we're not going to enforce that type of provision in a bond document.
Is a statute or is a contract not authorized by statute against public policy, or why wouldn't it be otherwise enforceable? Not all contracts are authorized by statute.
That's true, Your Honor, but our position is that that in order to be a valid aspect of the sentencing order, it has to be authorized under the statutes that govern sentencing, that govern what a court can do at sentencing in a criminal case. And so if this is not authorized, our position, as Judge McDonald wrote in his dissent in the Court of Appeals decision, is that individuals cannot agree or consent to legal terms of a sentence. And therefore, if there's no statutory authorization, then you still can't get there through consent. However, if the court disagrees with that, our position is, of course, that the signature on this bond document does not amount to enforceable valid consent and make that provision enforceable.
What if the terms of release were you can it'll be $10,000 bond, or it can be $5,000 bond, but if it's $5,000 at the end of the case, the balance can be applied to any fines that you already owe. Would that be lawful?
I don't believe it would, again, because that type of a condition would be aimed at something other than securing or ensuring the defendant's appearance and or safety of other persons, which is namely to make sure that financial obligations are satisfied. So I think there would be a problem with the statute that would not be a proper condition. And also under the reasoning in the Cohen case that I cited in additional authority, and also discussed to some degree in some of the other authorities before the court, when there is a condition that's imposed that's unconnected to the purposes of bond. It also violates the excessive bail prohibition in the federal and our state constitution as well. I would also suggest, in dealing with the County Attorney Association's amicus position, as I mentioned, that type of a reasoning that this money can be got at in other ways also ignores the purposes of bail and the legislative history of the bond chapter, namely given the fact that Iowa Code Section 811.8 sub 2 provides that at the conclusion of the proceeding and the defendant surrendered to custody, that the bond has to be returned to the defendant. I would suggest that again renders bond money different than other property of the defendant that may be held in the hands of a third party, and excludes it from valid debt collection procedures. That combined with the fact that, again, bail has a constitutional dimension, and in fact, under the Iowa Constitution, as distinct from the federal Constitution, there is a constitutional guarantee that of pretrial bail, not just that any bail imposed not be excessive, but that pretrial bail be available in cases other than capital cases. With that, unless there are additional questions, I will yield the rest of my time. Thank you.
Thank you as well, Counsel. Mr. Ogden.
Good afternoon. May it please the court. The defendant is asking this court to decide whether the district court has authority to order that any costs, fines, surcharges, restitution, that kind of thing that he's imposed can be deducted from his cash bail. While that's an interesting question, this is the wrong case for this court to decide that question for two reasons. First and most important reason is that that's not really what happened in this case. Second, even if it had, the defendant has not preserved that claim at all, and we just don't have the record to decide. So I would direct the court's attention to the order that's being challenged in this case, specifically paragraph 6 of that order, which is I believe on page 50 of the appendix. The judgment and sentence order has 8 paragraphs that go through the typical things that you see in this sentence: incarceration, fines, cost, restitution, and then some of the felony stuff, DNA profiling, that kind of thing. And in paragraph 6, I should start by saying each one of those paragraphs, when the judge is pronouncing the sentence, he uses the future directory shall or shall be. And in paragraph 6, what he says is the defendant's bond is forfeited and applied, and then he goes on to say that remaining payments shall be paid to the clerk due this day. And I think that what you can see from that is that the district court is recognizing the defendant's arrangement with the state to pay his costs and fines through the use of his cash bail money. And I think he's entitled to do that if he wants to. So what that tells us is that this was
based upon what section of the code?
Well, there's not a section of the code that speaks directly to that point, but as Chief Justice Cady pointed out, you can make these kinds of agreements even if they're not specifically permitted by statute. The code is silent to that. There really would be no difference here between the defendant taking the money back from the clerk after he's appeared and then just handing it straight back and saying, you know, I was convicted, I have some fines and stuff that I need to pay, here's the money.
Where's the evidence of this agreement in the record? I mean, was it part of the plea bargain?
Well, it was
Then there may be some problems with the plea bargain if you're going to do that, but where is the evidence in the record that this defendant voluntarily agreed to pay that money for the other fines?
Well, he signed a form when he posted his bond, and one of the things that's on the form, it says, I hereby authorize the clerk of court to use this money to pay any fines, court costs, restitution, et cetera, that I may be ordered to pay as part
But
of
if
this
that's an
matter.
illegal condition of the bond, that creates a problem.
Well, it would, certainly, but it's not a condition of the bond, and even the defendant agrees it's not a condition of the bond. It wasn't ordered by the magistrate. It's an arrangement that he made when he posted the bond.
Well,
But I
if
think
it's
we're-
if it's a standalone document that authorizes what occurred in this case, wouldn't it need to be supported by consideration?
Well, I think there is consideration
And
here.
where's the legal detriment here?
Well, I think that what the defendant is bargaining for in this case is essentially the convenience of having this money go straight to paying his fines rather than having
No, I
money
understand
returned to
that, but
him.
what would be the difference if I just said to everyone in the courtroom, I promise to give you $1 million? He said, I said, he says, I hereby promise to appear in court, and then I promise to authorize the clerk to use my bail bond to pay all my fines. So he's made a promise, but where's the return promise or legal detriment of the state?
Well, I think that the state is agreeing to, do something for him in exchange, which is to reduce his debt by the amount that he's paying, and do it in a way
The
that
the state's reducing his debt?
well, they're applying that money to his debt. So, he's basically pre-approving the payment of the debt in that way.
But isn't it just a naked promise that's the same that everyone in the courtroom would receive if I made the same promise?
Well, I don't think so, Mr. Chief Justice, but even if it was, I think that he would still have a problem because in this case, his promise has been performed and there was no objection to it, no withdrawal of that consent at any point in this case.
Here's kind of what I see as the heart of the problem with your position, Mr. Ogden. Your parents are in the courtroom, I could see. If my son got in trouble and I had to post a cash bond to bail him out, I might want to bail him out. I might want to get him out of jail, but I might not want to pay for all of his
Right.
fines and court obligations. I might want to maybe let that be his problem. And it does appear that this isn't just sort of a one-off deal. It appears from the record, at least that's before it, that this is a general policy in order to get to post bond, you have to agree that the funds that are posted can be applied toward your fines. And where's the authorization for that approach, assuming it's a general policy?
Right. Well, I think that the very last part of your question is key there because I think that what this really does is require us to make an assumption that I really don't think is in the record. We have the form. That's the only thing that we have. And we don't know, it's possible that there was more than one form and this is the one that they picked out if the defendant says he wants to pay his fines with the money. And this would have been very easy to sort out if the defendant had, for example, filed a motion to withdraw his consent or what he also could have done and probably should have done, which is to file a petition for writ of certiorari to the clerk of court after this has all been resolved if he didn't want them to use his money in that way. But to go back to answering your question, I think that that it would be a problem, of course, if you have third parties who are posting bond for defendants, and defendants are exceeding the scope of the authorization given to them by that third party by saying, yes, of course, you can take this money and pay my fine with it. You would have a problem there, and there's going to be some legal claims there, although I don't think that the claim in that case is the defendant against the state. Certainly you would have a claim against your son in that scenario, and you may have a claim against the state if the state had some kind of a reason to know that the scope of the authorization had been exceeded. But as far as the state and the defendant are concerned, there's not really a problem there.
Counsel, you had mentioned the statute is silent, but what about defense counsel's observation that Code Section 811.8 sub 2 says at the end of the process, basically, that the clerk shall return the bond money to the defendant? Does that stand in the way of, the argument based on the form?
Well, I don't think so, Justice Waterman, for two reasons. First, I think that that would be the kind of a provision that you could contract around. And second of all, I think that what you'll see in this case is that that's, in a way, what happened. And what I mean by that is we've been describing this as a forfeiture throughout this case, but it's really not a forfeiture. A forfeiture is a divestiture. You're losing the money. In this case, the defendant is not out any money at all. He had a debt that's now been paid. And so you could look at it as, instead of the clerk returned his money to him in the sense that that was money that was then applied to his debts. When you forfeit your bond, the money doesn't go to pay your court costs and fines. The money goes into the general fund, and you still owe all of those court costs and fines. So we know that the money wasn't forfeited in this case because he still got it.
What if this was a surety bond, though? I mean, you put up 10% and some insurance company, you see all those ads on TV, call Joe or something.
Right.
What if it's a surety bond? Can they take the surety bond and use that for the costs and things like that? Because he agreed, the bond posted it. There's no limitation. I mean, so how does that work when that happens?
Well, I think you would have the same problem in that case that you would have in the hypothetical that Justice Mansfield brought up, where you have a third party who's got an interest in this money, and the defendant certainly is not entitled to give that money up in payment of his fines if the surety doesn't allow it, or if the parent doesn't allow it, or whoever else. But that wouldn't be any different than if he had gotten the money back and then just given it to the clerk. And, the defendant is basically just taking the money at that point. But I would also point out that in this particular case, there's nothing in the record at all to suggest that anyone other than the defendant himself posted this bond. But the point, I guess the bigger point here is that the defendant has brought this case as a challenge that his sentence is illegal. And what I would like to point out to this court is that this is not part of his sentence at all. It's not punitive. It's not punishment. It's not really even something that's bad. In fact, I think you could look at it as, for a lot of defendants, this might be something that provides them with a real convenience. If you get your money back, you don't get it back in cash.
They used to say that about confessions of judgment, which were around long before you were here, which the U.S. Supreme Court said you can't do because you can't require someone to confess to a judgment without notice and hearing and things like that. So you're espousing that old system, I take it.
Well, not necessarily, Justice Wiggins, because I think there's something a little bit different about this particular situation. I mean, usually you would get a check from the clerk, and if you're a defendant, maybe you don't have a bank account or any way of handling that, and it's just easier for you in a case. Because the other thing is that the defendant, when he agreed to this, he may have gotten acquitted. I think the dissent in the Court of Appeals described this as him giving up this money in exchange for his bail, but that's really not what happened because as I said before, the money goes to pay his fines, but he may not have actually owed it at all, and then he would have gotten it back after he was acquitted.
I think you make a good point that normally bond and the forfeiture of bond or any of these questions are not part of the sentencing.
Right.
But in sort of an odd way, you've pointed out the paragraph 6 there that this court did choose to include that as one of the terms of the sentencing order.
Well, that's true, but I think the point that I was trying to make, and maybe I didn't say it very artfully, but the point I was trying to make is that when he put that in there, he wasn't ordering it, he was just noting it.
Carrying out what had previously been promised.
Right, or maybe not even necessarily carrying it out, but just putting it there, to explain what comes after that, which is that any remaining obligation shall be due and payable on that day.
The defendant could have gone to the clerk's office and demanded the money back because the order wasn't binding. Is that what you're saying?
Well, I don't think that he could have gone to I think that you bring up an interesting point, which is what would have happened had this not been in the district court's order at all. And I think that that's a good reason for us to understand that it's not part of his sentence, because what would have happened is the same thing that happened anyway, because the clerk would have presumably looked at the form and said, here's an authorization. He could have maybe try to take that back. As Chief Justice Cady pointed out, you know, if we look at this as more of a unilateral promise than a two-way street, it's possible he could have withdrawn that consent at that point. You know, he certainly didn't do that as far as we know. And there are other, you know, he had other avenues where he could have challenged this before as well, and frankly, I think could have obtained relief probably, because it's highly unlikely that the district court would have put this into its order at all if you hadn't had this form and the arrangement that was already made. I don't have any other comments, so if there are no other questions, the state would respectfully request that this court affirm the Court of Appeals. Thank you.
Mr. Ogden, thank you as well. Rebuttal argument?
Thank you, Your Honor. Defendant's understanding and position, again, is the question presented here is whether the language in the challenge language in the sentencing order is to be given effect, and whether that independently authorizes application of the cash bail to these financial obligations in the county. And defendant's position is that it does not, because it is not authorized by statute, and it is contrary to Section 811.8 sub 2, which says that the money has to go back to the defendant upon his surrender.
Let's say at the end of the sentencing, there was just a question asked. Let's say at the very end of the sentencing, I'm not saying it's the facts here, it was just a question asked, hey, are you okay with forfeiting the bond money? You want to just go ahead and take care of your obligations, your monetary obligations under this sentence right now? And the defendant said, yeah, that's fine. There wouldn't be a problem with that, would there?
Well, I think the problem is that the sentencing judge is doing it. I think if that happened with the clerk of court, certainly. I think perhaps the defendant could at that point authorize that. But there's not authority to put it into the sentencing order. It is not within the powers of the district court at sentencing to impose that.
What about Mr. Ogden's argument that the sentencing order has different words in each provision? The other 5 provisions or whatever all start out by the court ordering something. You shall, you shall, you shall. And then we get to paragraph 6, and the court just reiterates. For instance, the judge could have been going through the file and sees this this promise that's been documented and says, "Oh, there you go," and puts in there that the bond is forfeited as pursuant to the promise here.
So I guess I would disagree with that reading of the language is forfeited and applied, because to me that indicates that is being done as a result of this order. It's not just that the court is documenting something that has happened separately and is making it clear for the record. That's what judge is doing by putting it in the sentencing order. It is saying it is hereby, by my action here, it is forfeited. But again, to the extent that takes us back to whether the signature on the appearance bond with the form language is to be given effect, again, the defendant's position would be that that's not voluntary consent. There is no consideration. It is a contract of adhesion. It is not to be, it cannot be enforced, and again, it is contrary to Section 811.8 sub 2 and the
Mr. Hill?
May it please the court, counsel. The issue before the court today is one of the earned time accumulation rate for juveniles who have been convicted of 902.12 offenses and who have been resentenced after Lyle. What this really means is what is going to be their earn time rate? Are they going to earn 1.2 days for every day served or 15/85 for every day served? In English somewhat, this is about a 40% reduction in their sentence. The question was presented to the trial
Mr.
court.
Can you answer a question for me? Why did they come up with 15/85?
15/85, it's a great question, and it comes down to a math answer. In order to get earn time, the earn time should only apply to the first 85% of the sentence. And so if you apply the 15/85 to all of the days, 100% of the days, you get about a 17% reduction in sentence. 15/85, if you do the math, it will equate so that if the person earns every day and never loses a day, he will actually discharge at 85%.
Yeah, I did the math a little differently, and I took a 50-year sentence with a 35 minimum, 70%. And if you do the math, it turns out that 7.5 years into that last 15 years that are not mandatory, you get out. So you end up getting a day for a day, basically. I mean, that's what the math is. It turns into a day for a non-mandatory minimum, for the non-mandatory part of a minimum sentence.
All right. And I'm a lawyer, not a mathematician, and I understand that, and we've worked the numbers, and that's how they come out. It does work out that if you earn 15/85 for 8.5 years, that equates to a 10-year sentence.
That was done that way because you want to have some kind of hook. Hook's a bad word, but some kind of incentive for someone to be good even though they can't get out for 30 or 40 years. But at least when they start in the non-mandatory minimum part, they'll get a day for day, like if they didn't have a mandatory.
No, they don't get it day per day after.
Well, it turns
yeah.
out to be a day for day on the non-mandatory part. That's what the math does on these sentences.
I disagree. And I've had cases before where I present the whole mathematical equation of how we get the calculation, and the Department of Corrections breaks it down to 6 decimal points, and we can do the actual on-paper math.
I only did it to 2 decimal points, so.
Okay. Well, it works, and we get these challenges at the district court level all the time of figuring out the sentence, figuring out the jail credit, and that's what I spend a lot of my time on. But
Sorry, go ahead.
Counsel, yeah, I'm going to follow up on Justice Wiggins' question. Did they do a different or a slower accrual rate for sentences with mandatory minimum to avoid a situation where by behaving and accruing good time, you'd be otherwise eligible for release before the mandatory minimum term had run?
I think I understand your question, and to me, there's a difference. Remember, under 902.12, these are what I call minimum sentences. It's a hard 70. Earn time doesn't reduce it. In a normal situation, what you would call a mandatory minimum under a drug offense, it's reduced by earn time, so that mandatory minimum gets cut to 45.45%. Minus jail credit, and so it ends up being a pretty low number.
Well, let me ask it this way. Why did the legislature provide for 2 different accrual rates?
Oh, easy answer, because the type of offenses. The type of offenses that it applied to were the most heinous offenses. It put 2 hooks in them, so to speak. One was that you serve 70% of your sentence before you're eligible for parole, and the other one was the 15/85 to increase the amount of time that you actually spent in prison. And it kind of makes sense from a legislative perspective of the offenses for which 902.12 apply are some of the most heinous offenses. They're the murder second, the attempted murders, the robbery first and second, kidnapping second, sex abuse second.
Here's the question, Mr. Hill. I mean, I don't want to belabor the math too much, and I haven't studied the numbers probably like my colleagues have, but so if Mr. Allen's client prevails, as I understand the situation, what we've already done is said there are no mandatory, that what the legislature considered a mandatory minimum for a given sentence as applies to juveniles is no longer a mandatory minimum. What would now happen is it would no longer be a maximum either in some of these cases. Is that right? Because there would be enough earned time that you would get below your release date would end up being less than or earlier than the period of the mandatory minimum, is that right?
To give you an idea, for Ms. Breeden, her current tentative discharge date is November 14th, 2023. If the court were to rule, as the Court of Appeals ruled, that she gets 1.2 days from the very start, she would have discharged in 2013. Same thing with Ms. Hoochmouth, although she has a longer sentence, her TDD is the earliest she could discharge with all potential earn time credits. Currently is July 2nd, or July 26, 2040. Her new discharge date with 1.2 from her very admission would take her down to May 21st of 2021.
Are these provisions severable, for example? I mean, you mentioned two hooks. These are heinous crimes. We're going to, require the 70% or the mandatory minimum, and also the slower accrual rate, the 15/85 instead of 1.2. If we take away in Lyle the mandatory minimum, can we still use the slower accrual rate under our general duty to save as much of a statute as possible if it's severable?
Yes. I think the two provisions, both the 70% requirement and the 70% requirement that they serve 70% before they're eligible for parole, it's a minimum sentence, earn time doesn't apply to reduce it. That provision itself is separate and distinct and operates.
Well, but counsel, you describe it as separate and distinct, but this court back in 2000 characterized that, the combination of 903A2 and 902.12 as an aspect of the mandatory minimum. And the whole rationale for resentencing this person is to get rid of that. And so, based on what we've already said about the combination of these statutes, isn't the conclusion foregone here?
I think what you're referring to is in the commutation case, the Lowry case.
Yeah, but it's the case I'm referring to is State versus Iowa District Court for Blackhawk County.
Okay.
It's a 2000 Iowa Supreme Court.
Right, and in Blackhawk County, that's when they were one. It was a true 85-85. That is, you had to serve 85% before you're eligible for parole, and you could only earn time up to 85%. Then it went down to 85-70, and what I think the Blackhawk County case recognizes in its progeny is they separated those two aspects. That's the point where those two diverged, and they said you have two distinct and separate aspects. You have the minimum sentence, and you have the minimum parole eligibility. And the argument that I have in what urging the court to adopt is certainly while Lyle got rid of the minimum parole date of 70%, the other aspect, the 15/85, remain viable. And it's the viability of that aspect is because of, I think what you have to do is mind back to what's really at issue in this case. Why did they have the 15/85? And the reason was because of the nature of these crimes. These were the worst crimes. We're going to make sure that these people do longer in prison. Doesn't mean that they're not going to be eligible for parole if they were juveniles, because in this particular case, both petitioners, Breeden and Hoochmouth, are now out on parole. So in essence, Lyle worked. These individuals are out on parole and hopefully doing well.
Does that make this case moot?
No, I don't think so, because the court also has two other cases here today. One's still in prison. I think it's the type of issue that we need a resolution for, because we have this subclass of, like Anderson versus State, the probation credit deal, where we have to deal with these folks in the interest of the Department of Corrections. The state of Iowa is to get it right and to follow the law. And what we think the law is that they set up this system whereby there's these two sets of offenders, those who commit normal offenses and those who commit bad ones. And for those who commit bad ones who are juveniles, we're going to make them parole eligible. We're just going to have a longer period of supervision for them. And that's really what we think the legislative intent was, looking at the entire picture of what was going on to these particular offenders, is that because of the type of offense for which they were convicted, is that these are the types of individuals for whom a different earn time rate applies. And that's what we would assert is consistent with Lyle, consistent with the statutory language. Understandably,
Did we already decide this in Lowry?
in Lowry is a difficult case because it was decided upon the language of the commutation, and the court in Lowry kind of split it halfway. Because Governor Culver had some language saying that this guy should be vetted by the parole board, so therefore maybe we didn't mean to. Lowry, I think, from one, can be limited to the fact that it's a commutation case and be looked at from that angle. If
You know, the second half of Lowry, we said, from the date of the commutation order henceforward, Lowry is entitled to earn time at the faster rate. So why, if we apply Lowry here, why don't Breeden and Hochmuth, or not them, but whoever really needs the relief, why aren't they entitled to the same faster rate?
Well, the reason is because I think you got to go back to the statutory interpretation. I think Lowry in the big picture was decided as a commutation case, and there was no, I can't remember the time frames if at that time Lyle had been decided, the potential impact of it. I think at the time
I'm not sure that it had been, but nonetheless, the issue, essentially the state prevailed, but in getting the slower earn time rate, but only on the theory that the governor had not intended that Lowry get the faster rate up until the date of the commutation order. After that, Lowry got the faster rate, which seems to me consistent with the positions that Breeden and Hochmuth are arguing here.
Right, and I think if you say that Lowry is the end point, then Lowry needs, the rationale underlying Lowry needs to be reexamined pursuant, because there's not this statutory analysis of, gee, what was the legislature intending to do here? Because it almost seems as if we look at how we're getting to this point is somewhat of an unintended consequence of Lyle,
But is it really, you know, when we say the sentence originally given was illegal, we replace it with a legal sentence. So you got a brand new sentence, and the brand new sentence is not subject to mandatory minimums. The language of the code is, and it's in 903A2B, says, sentences are those sentences which are subject to a maximum accumulation earned time of 15 under section 90212. And it's referring to 90212, but when we replace the sentence, it's no longer a 90212 sentence. So by replacing the sentence, I don't know how the language of the statute gets you back, and maybe I'm reading this wrong, but how the language of the sentence gets back, because you no longer have a 90212 sentence. And I think the law is, and maybe I'm wrong here and you can explain it to me, is that the new sentence took the place of the old sentence, so you never had a mandatory minimum sentence.
That's because in what we're arguing about and what you'll hear from counsel here in a moment is it's the sentence. What we would argue is it's the conviction. These individuals were still convicted of a 90212 offense. They were still convicted of these heinous offenses for which they have a slower earn time rate. And if one were to look at the true statutory interpretation, instead of kind of jumping from what was the sentence to, basically the argument is...
The statute uses the word sentence, not conviction. It says a sentence pursuant to that section, not a conviction pursuant to that section.
But we're looking at the sentencing statute, not the earn time statute. And the earn time statute says 1585th for this type of offense.
For a person sentenced under that statute, not convicted. They don't use the word conviction.
And I understand. That's why we're at this loggerhead that needs to be disputed, and we could argue this point all day about which should control 90212 or 903B and what was in effect. But that's why I think one has to mind back to what's the intent of what the legislature wanted to do. And it's the position of the state that what they wanted to do in this case was to hold these individuals accountable and have a longer string over them. So we would ask that the decision of the district court be affirmed.
Thank you, Mr. Hill. Mr. Allen.
Thank you. May it please the court, Counsel Hill. Listening to the court's questions, unless they're rhetorical, I have to ask, why am I here? To get to the department's position, I think you have to ignore the clear reading of the statute. You have to ignore the district court's order, which in handwriting, the judge said, let the Department of Corrections be very clear, there is no mandatory minimum. You have to ignore the sentencing structure. You have to ignore Lyle's decision, which says no one-size-fits-all for these juvenile defendants, and what the department's what the department's interpretation is.
You know, I mean,
one size
I
fits
think
all.
reasonable people can disagree on this argument, on this issue. What we're dealing with is the legislature has one statute cross-referencing another, and the cross-reference says the Category B sentences are those sentences which are subject to a maximum accumulation of earned time of 15% of the total sentence of confinement under Section 902.12. And then 902.12 lists a series of offenses and says the person serving a sentence shall be denied, for these offenses shall be denied parole or work release until they've served 7/10. So you want to emphasize the fact that the legislature used the word sentence, but one could arguably just say it was a convenient way of cross-referencing that particular list of offenses, right?
Yeah, it's a convenient way of cross-referencing, I understand that. But when you get back to 902.12, as Justice Wiggins pointed out, it is no longer a 902.12 sentence, because the language, except for juveniles who have been resentenced, has been juxtaposed onto that.
I mean, we can, I think if you're right, if we apply a strict blue penciling approach, you're probably right.
Well, it's a constitutional requirement.
Well, but normally, when we we declare part of a statute unconstitutional, we try to save as much of the statute, as much of the legislature's scheme as possible. Here, we declared the mandatory minimum unconstitutional as applied to juveniles, but we've also now, in effect, shortened the actual sentence based on the earned time accumulation.
Well, let me offer two reasons for that. One of which is Lyle stands for the proposition not only that mandatory minimums shall be eliminated, but the reason that mandatory minimums are eliminated is because the one-size-fits-all for all juveniles is no longer applicable. What the department's position is on the earned time is that for these juveniles, despite the fact that they have had their mandatory minimums removed, they are still treated as one-size-fits-all. They all get the 15/85 instead of the 1.2, so they're still being treated in conflict with Lyle. Secondly, when you put that into the statute itself, what you've done is you've created what was originally unconstitutional, and you've now, because you want to make the switch from one statute to the other, because the legislature made the reference, you've transferred that unconstitutional one-size-fits-all into the sentencing statute, and you've done that for the very reason, as Mr. Hill points out, because it's an additional hook, because of the nature of the severity of the crime, or because these are heinous individuals. All three of those criteria are in violation of Miller. Miller says those criteria for juveniles should be considered by the juvenile court, by the sentencing court, which they were, because no mandatory minimum was imposed.
But are we dealing with a constitutional case today, or are we simply dealing with statutory interpretation?
Well, as you can see by my resistance to the application for further review, my constitutional argument is on the tag in, because we don't get to it, I don't think, because we're limited by the statute itself. The statutory interpretation, if you look at it, as Justice Wiggins pointed out, you look at it, it is a sentencing guideline statute. The word conviction, Mr. Hill can't find it. The word crime, it's not in the statute. The statute itself, you just read it. It is a sentencing category. And if you have a Category A sentence, which has no mandatory minimum, or if you have a Category B sentence, which may have a mandatory minimum, then you impose and you apply the statute as it's written. You don't even get to 902.12, and if you get to 902.12, then the constitutional argument may arise. But I would suggest that under long-standing statutory interpretation, you just follow the statutes that is there. which simply says the word conviction, the word crime is not there. We're not looking at the heinousness of their acts. We're looking at what is the sentence that they are now serving. And both of these individuals, because of the re-sentence by the district court, where she put in no mandatory minimum, neither of these individuals are serving mandatory minimums. And when you apply 903A.2 as a sentencing category, they are getting the 1.2. Does that mean?
Counsel, if we think the statute can be read either way, and then look at our other tools of construction, including the purpose of it, what was the legislative purpose of having the 1585ths for the more serious forcible felonies?
I think Mr. Hill is accurate on that. I think the legislative interpretation, legislative intent was for heinous crime back in the day when we did mandatory minimums for a heinous crime. For these particular individuals, we wanted to make them sit there a longer time. But for the juvenile class, for those individuals who got re-sentenced because of the policy underlying Miller and the Iowa cases, that no longer applies.
But they're still resentenced for a conviction that's listed in 902.12, so why aren't those provisions severable?
Well, fine, but you can't get from, it's like trying to get to Cedar Rapids in a flood season. You can't get there from here. You can't get from 902.12 to the sentencing of 903A.2 because the word conviction, the word crime, the word heinous is not in there.
You can't rely on the statutes alone and get to the outcome we got in Lyle. Well, the point is we declared aspects of the statutes unconstitutional. We now have to try and put together put things back together, be faithful to Lyle, but also preserve as much of what the legislature intended as we can.
And let me also suggest that we need to preserve as much of Lowry as we can. Lowry has already answered this question. For purposes of commutation, Mr. Hill would like you to believe that commutation is somehow different than resentencing. But for that period of time, subsequent to the date of the commutation, as you suggested, Lowry has already answered this question. Lowry says, if Lowry had been sentenced to a term of 25 years with no mandatory minimum, he is entitled to the faster rate. The new sentence gives effect to the plain language of the statute. That is exactly what happened to these individuals. They were sentenced to a term of years with no mandatory minimum, and according to this court's pronouncement in Lowry, they are entitled to the faster rate.
What
the
about
decision's already been answered.
I know we said that in Lowry, but what about your opposing counsel's argument that we should distinguish Lowry as a commutation case, and maybe one way to look at it, maybe, is that Lowry didn't invoke this duty to save as much of a statute. It was a one-up governor exercising his power to commute a sentence. It's not like this part of the statutory scheme is unconstitutional. Does that take down the other part, or can we separate them? Different question?
I think it's a totally different question, and Justice Waterman, I can give you that for purposes of that portion of the sentence which occurred prior to the commutation. In that particular instance, the individual Lowry and the individual Breeden are exactly in the same situation, mandatory minimum. But for that period of time, subsequent to the date of the commutation and the date of the re-sentence, they remain the same. They neither one have a sentence with a mandatory minimum. They neither one are subject to 902.12. They are under 903A.2. Neither have a mandatory minimum, either subsequent to the commutation or subsequent to the re-sentence. It's a new sentence, replaces the old void, and so consequently they are under 903A.2 entitled, under Lowry, to the faster accumulated rate.
I can ask Mr. Hill this, and maybe I should, but do you know what is going on with folks that we're not talking about a resentencing, but they've been sentenced for one of these more serious crimes even after the legislature adopted the 905.14 provision. Are those folks under DOC policy accumulating earned time at the slower rate or the faster rate?
You'll have to ask Mr. Hill that. The portion of your question that I can answer is that there are a lot of Breeden and Hochmuths out there. There are a number of cases from Scott County that are sitting around waiting for the result in this case District court judges are generally applying the faster rate because they're reading the statute. The Department of Corrections is responding to most of those in the same way they're responding to this case. So that of the 45 or 47 juveniles under this court's cases that need to be resentenced, they will all face this problem because the department is taking a uniform position that they all get at the slower rate, not the faster. Based upon what I believe is clear statutory interpretation to avoid the constitutional problem, and because Lowry and the principles and policy behind Lyle control this, I think the Court of Appeals had it right when they said, clear statutory instruction, these people are entitled to the faster rate for that period of time. For Ms. Breeden, as Mr. Hill has already pointed out, 2.5 years ago she would have been discharged. Is this case moot? No. She's continued to be under parole. She's continued to have to report. She's continued to do monthly and weekly surveys. She is continually under the jurisdiction of the Department of Corrections and will remain so until 2023 unless this court affirms the Court of Appeals. Thank you.
Mr. Allen, thank you as well. Rebuttal, Mr. Hill?
Begin by just quickly answering my question. Is DOC taking the same position even as to juveniles, say, that currently commit these more serious forcible felonies and are sentenced?
Yes. And by, estimates, we know that this case only involves 2 individuals. We have Mr. Coleman and Mr. James being submitted non-orally. The estimate is there's about 150 people who are fit in this class of juveniles resentenced under 902.12 that are out there. What I think the problem that the court has is we're basically trying to reverse engineer 902.12 and 903A.2 based upon the subsequent Lyle decision and trying to apply it to an issue never envisioned by the legislature. And that's why I think one has to go back to what the legislature really intended. If the words are, if we're fighting over conviction and sentence, we can't read all logic out of the statute to get a result which doesn't seem consistent with what was intended. And what was intended was, for this class of offenses, they wanted a longer period of control over them. And this really does fit hand in hand with the Lyle decision. Lyle decision said we had nothing to do with the length of the sentence, we just want to give them the opportunity for parole. And as evidenced by the 2 offenders in this case, they're both out. And they're both doing well, they're just under a longer period of supervision. Will they be under that period of supervision forever? No. There are certainly, if they've received maximum benefits, there's provisions under the parole code which allow them to discharge early. But based upon their conviction, not because they were juveniles or because of anything else, they just want to keep a closer eye on them and to protect the public safety and all the circumstances that arise from supervision while on parole. So in this particular case, if you get to the statutory interpretation and have to get to what ill was sought to be achieved, it was to have a longer period of supervision for what are the most serious types of offenders. We would assert that the question presented to the court today is primarily statutory interpretation, and we believe that the statute, you can get there from here. It's a question of what was intended in the conviction of the individuals. So we would assert that the decision of the underlying trial court was correct, and the trial court decision should be affirmed. Unless there are further questions, I'll waive all remaining time. Thank you.
Mr. Hill, thank you as well. Thank you for your arguments. And the case is now submitted, and the bailiff may adjourn.